Chapter 15, Interstate Relations. The successful functioning of the Indian federal system depends not only on the harmonious relations and close cooperation between the center and the states but also between the status inter se. Hence, the Constitution makes the following provisions with regard to interstate comity. Number 1. Adjudication of interstate water disputes. Number 2. Coordination through interstate councils. Number 3. Mutual recognition of public act records and judicial proceedings. Number 4. Freedom of interstate trade, commerce and intercourse. In addition, the zonal councils have been established by the parliament to promote interstate cooperation and coordination. Interstate water disputes. Article 262 of the Constitution provides for the adjudication of interstate water disputes. It makes two provisions. First, Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution, and control of waters of any interstate river and river valley. Number 2. Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect of any such dispute or complaint. Under this provision, the Parliament has enacted two laws, the River Boards Act 1956 and the Interstate Water Dispute Act 1956. The River Boards Act provides for the establishment of river boards for the regulation and development of interstate river and river valleys. A river board is established by the central government on the request of the state government concerned to advise them. The Interstate Water Dispute Act empowers the central government to set up an ad hoc tribunal for the adjudication of a dispute between two or more states in relation to the waters of an interstate river or river valley. The decision of the tribunal would be final and binding on the parties to the dispute. Neither the Supreme Court nor any other court is to have jurisdiction in respect of any water dispute which may be referred to such a tribunal under this Act. The need for an extrajudicial machinery to settle interstate water dispute is as follows. The Supreme Court would indeed have jurisdiction to decide any dispute between states in connection with water supplies if legal rights or interests are concerned, but the experience of most countries has shown that rules of law based upon the analogy of private proprietary interest in water do not afford a satisfactory basis for settling disputes between the states where the interest of the public at large in the proper use of water supplies are involved. So far, 2019, the central government has set up 9 interstate water dispute tribunals. The name of the tribunals, the years in which they were constituted, and the state involved in the dispute are mentioned below. Number 1. Krishna Water Dispute Tribunal first. It was set up in 1969 and states involved Maharashtra, Karnataka and Andhra Pradesh. Number 2. Godavari Water Dispute Tribunal. It was set up in 1969 and the states involved Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh and Odisha. Number 3. Narmada Water Dispute Tribunal. It was set up in 1969. The states involved are Rajasthan, Gujarat, Madhya Pradesh and Maharashtra. Number 4. Ravi and Bias Water Dispute Tribunal. It was set up in 1986. The states involved are Punjab, Haryana and Rajasthan. Number 5. Kaveri Water Dispute Tribunal. It was set up in 1990. The states involved Karnataka, Kerala, Tamil Nadu and Puducherry. Number 6. Krishna Water Dispute Tribunal 2. It was set up in 2004. The states involved are Maharashtra, Karnataka and Andhra Pradesh. Number 7. Vanshadhara Water Dispute Tribunal. It was set up in 2010. States involved are Odisha and Andhra Pradesh. Number 8. Mahadai Water Dispute Tribunal. It was set up in 2010. States involved are Goa, Karnataka and Maharashtra. Number 9. Mahanadi Water Dispute Tribunal. It was set up in 2018. States involved are Odisha and Chhattisgarh. Interstate Councils. Article 263 contemplates the establishment of an interstate council to effect coordination between the states and between center and states. Thus, the President can establish such a council if at any time it appears to him that the public interest would be served by its establishment. He can define the nature of duties to be performed by such a council and its organization and procedure, even though the President is empowered to define the duties of an interstate council. Article 263 specifies the duties that can be assigned to it in the following manner. A. Inquiring into and advising upon disputes which may arise between states. B. Investigating and discussing subjects in which the states or the center and the states have a common interest. C. Making recommendations upon any such subject and particularly for the better coordination of policy and action on it. The Council's function to inquire and advise upon interstate dispute is complementary to the Supreme Court's jurisdiction under Article 131 to decide a legal controversy between the governments. The Council can deal with any controversy, whether legal or non-legal, but its function is advisory unlike that of the court, which gives a binding decision. Under the above provision of Article 263, the President has established the following councils to make recommendations for the better coordination of policy and action in the related subjects. Central Council of Health and Family Welfare, Central Council of Local Government, 4 regional councils for sales tax for the northern, eastern, western and southern zones. Establishment of Interstate Council. The Sarkaria Commission on the Center-State Relations 1983-88 made a strong case for the establishment of a permanent interstate council under Article 263 of the Constitution. It recommended that in order to differentiate the interstate council from other bodies established under the same Article 263, it must be called as the Intergovernmental Council. The Commission recommended that the Council should be charged with the duties laid down in Clause B and C of Article 263. In pursuance of the above recommendation of the Sarkaria Commission, the Janata Dal government headed by VP Singh established the Interstate Council in 1990. It consists of the following members: Prime Minister as the chairman, Chief Minister of all the states, Chief Minister of Union Territories having legislative assemblies, administrators of union territories not having legislative assemblies, governors of a state under President's rule, 6 central cabinet ministers including the Home Minister to be nominated by the Prime Minister. 5 ministers of cabinet rank, Minister of a State, independent charge, nominated by the chairman of the council, that is, Prime Minister, are permanent invitees to the council. The council is a recommendatory body on issues relating to interstate, center-state and center-union territories relations. It aims at promoting coordination between them by examining, discussing and deliberating on such issues. Its duties in detail are as follows: investigating and discussing such subjects in which the states or the center have a common interest, making recommendations upon any such subject for the better coordination of policy and action on it, deliberating upon such other matters of general interest to the states as may be referred to it by the chairman. The council may meet at least thrice in a year. Its meetings are held in cameras and all questions are decided by consensus. There is also a standing committee of the council. It was set up in 1996 for continuous consultation and processing of matters for the consideration of the council. It consists of the following members: Union Home Minister as the chairman, 5 Union Cabinet Ministers, 9 Chief Ministers. The council is assisted by a secretariat called the Interstate Council Secretariat. This secretariat was set up in 1991 and is headed by a secretary to the Government of India. Since 2011, it is also functioning as the secretariat of the Zonal Council. Public Act, Record and Judicial Proceedings. Under the Constitution, the jurisdiction of each state is confined to its own territory. Hence, it is possible that the act and records of one state may not be recognized in another state. To remove any such difficulty, the Constitution contains the full faith and credit clause, which lays down the following. First, full faith and credit is to be given throughout the territory of India to public act, record and judicial proceedings of the centre and every state. The expression public act includes both legislative and executive act of the government. The expression public record include any official book, register or record made by a public servant in the discharge of his official duties. Number 2. The manner in which and the conditions under which such act, record and proceedings are to be proved and their effect determined would be as provided by the laws of Parliament. This means that the general rule mentioned above is subject to the power of Parliament to lay down the mode of proof as well as the effect of such act, records, and proceedings of one state in another state. Number 3. Final judgments and orders of civil courts in any part of India are capable of execution anywhere within India without the necessity of a fresh suit upon the judgment. The rule applies only to civil judgments and not to criminal judgments. In other words, it does not require the courts of a state to enforce the penal laws of another state. Interstate trade and commerce. Article 301 to 307 in Part 13 of the Constitution deal with the trade, commerce, and intercourse within the territory of India. Article 301 declares that trade, commerce, and intercourse throughout the territory of India shall be free. The object of this provision is to break down the border barriers between the state and to create one unit with a view to encourage the free flow of trade, commerce, and intercourse in the country. The freedom under this provision is not confined to interstate trade, commerce, and intercourse, but also extends to intra-state trade, commerce, and intercourse. Thus, Article 301 will be violated whether restrictions are imposed at the frontier of any state or at any prior or subsequent stage. The freedom guaranteed by Article 301 is a freedom from all restrictions except those which are provided for in the other provisions. Article 302 to 305 of Part 12 of the Constitution itself. These are explained below. Number 1. Parliament can impose restrictions on the freedom of text, commerce, trade, commerce, and intercourse between the state or within a state in public interest. But the Parliament cannot give preference to one state over another or discriminate between the state except in the case of scarcity of goods in any part of India. Number 2. The legislature of a state can impose reasonable restrictions on the freedom of trade, commerce, and intercourse with that state or within that state in public interest, but a bill for this purpose can be introduced in the legislature only with the previous sanction of the President. Further, the state legislature cannot give preference to one state over another or discriminate between the state. Number 3. The legislature of a state can impose on goods imported from other states or the union territories any tax to which similarly goods manufactured in that state are subject. This provision prohibits the imposition of discriminatory taxes by the state. Number 4. The freedom under Article 301 is subject to the nationalization laws, that is, laws providing for monopolies in favor of the center or the state. Thus, the parliament or the state legislature can make laws for the carrying on by the respective government any trade, business, industry, or service, whether to the exclusion, complete or partial, of citizens or otherwise. The Parliament can appoint an appropriate authority for carrying out the purpose of the above provisions relating to the freedom of trade, commerce, and intercourse and restrictions on it. The Parliament can also confer on that authority the necessary powers and duties, but no such authority has been appointed so far. Zonal councils. The zonal councils are the statutory and not the constitutional bodies. They are established by an act of parliament, that is, State Reorganization Act of 1956. The act divided the country into 5 zones: northern, central, eastern, western, and southern, and provided a zonal council for each zone. While forming these zones, several factors have been taken into account, which include the natural division of the country, the river system and means of communication, the cultural and linguistic affinity, and the requirement of economic development, security, law and order. Each zonal council consists of the following members: Home Minister of Central Government, Chief Minister of all the states in the zone, 2 other ministers for each state in the zone, Administrator of each union territory in the zone. Besides, the following persons can be associated with the zonal council as advisors, that is, without the right to vote in the meetings: a person nominated by the Planning Commission, Chief Secretary of the Government of each state in the zone, Development Commissioner of each state in the zone. The Home Minister of Central Government is the common chairman of the 5 zonal councils. Each Chief Minister acts as a Vice Chairman of the Council by rotation, holding office for a period of 1 year at a time. The zonal councils aim at promoting cooperation and coordination between states, union territories, and the center. They discuss and make recommendations regarding matters like economic and social planning, linguistic minorities, border dispute, interstate transport, and so on. They are only deliberative and advisory bodies. The objective or the functions of the zonal council in detail are as follows: to achieve an emotional integration of the country, to help in arresting the growth of acute state consciousness, regionalism, linguism, and particularistic trends, to help in removing the after effects of separation in some cases so that the process of reorganization, integration, and economic advancement may synchronize, to enable the center and state to cooperate with each other in social and economic matters and exchange ideas and experience in order to evolve uniform policies, to cooperate with each other in the successful and speedy execution of major development projects, to secure some kind of political equilibrium between different regions of the country. Northeastern Council. In addition to the above zonal councils, a Northeastern Council was created by a separate Act of Parliament, the Northeastern Council Act of 1971. Its members include Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, Tripura, and Sikkim. Its functions are similar to those of the zonal councils but with few additions. It has to formulate a unified and coordinated regional plan covering matters of common importance. It has to review from time to time the measure taken by the member state for the maintenance of security and public order in the region. Zonal councils at a glance. Number 1. Northern Zonal Council. Members are Himachal Pradesh, Haryana, Punjab, Rajasthan, Delhi, Chandigarh, Jammu and Kashmir, and Ladakh. Headquarters is in New Delhi. Number 2. Central Zonal Council. Members are Uttar Pradesh, Uttarakhand, Chhattisgarh, and Madhya Pradesh. Headquarters is in Allahabad. Number 3. Eastern Zonal Council. Members are Bihar, Jharkhand, West Bengal, and Odisha. Headquarters is in Kolkata. Number 4. Western Zonal Council. Gujarat. Members are Gujarat, Maharashtra, Goa, Dadra and Nagar Haveli, and Daman and Diu. Headquarters is in Mumbai. Number 5. Southern Zonal Council. Members are Andhra Pradesh, Telangana, Karnataka, Tamil Nadu, Kerala, and Puducherry. Headquarters is in Chennai.